done by your.
Yes, yes.
But we'll come to the issue. According to me, is maintainability. Your lordships will have to decide that the High Court. So your lordships will have to now assume that the High Court can't deliver justice. Fine, but I'm not saying don't. But your lordships will have to say that,
You cannot put words into our mouth.
No, I'll say your lordship.
Assume and what we will not assume.
If your
our
lordship,
business.
of course,
Mr. Sibbal.
of course. But I'm not saying, your lordship.
Please argue your case.
I'm going to argue,
What we will.
My argument at the initial. They're in the midst of an election. What are they doing in 2024? What were they doing in 2025? And why were they so keen in the midst of an election in 2026?
Vicky Dada, BJ show.
Law and order.
West Bengal are conducted by IPAC or by the election?
No, all the material, the sequence of information, of facts, all that is confidential and it is kept there. And I'm sure that the ED knows about it. He knows about it. So when they went there, they knew that there's going to be a lot of information in respect of the party, the candidates, what is happening, what is the program, where we're going to go, what we're going to do. I'm sure they knew about it. So, the first question that arises is, why was the need to go there in the midst of an election? Why was the need to go there in the midst of an election? Now, in the coal scam that we are talking about, the last statement in the coal scam was recorded on the 24th of February. 24th of February, 2024. What were they doing in 2024? What were they doing in 2025? And why were they so keen in the midst of an election in 2026? And we're saying we want for what? SIR for what? It is all the information that's in the computer. Once you get possession of that information, how are we going to fight the election? So, which is why the chairman, the chairman has a right to go. It's the property of the party. So the chairman then went, because they went to the house of IPAC, the individual Pratik Jain, in the morning, in the morning, at 6:20 in the morning.
Yes.
ED went at 6:20. Chief Minister only came at 12 o'clock, and went away at about 12:15.
They collected everything in it.
There is a provision in the BNSS which says that 105. And the lies will be demonstrated if they show the video. Take 105 of BNSS. We are also very disturbed, extremely disturbed as to what is happening. Why should ED wait for 2 years to come to West Bengal and go to an office which is a party office, which has all the data with all the information? It's part of party office. Kindly see 105. The process of conducting search of a place or taking possession of any property, article or thing under this chapter, or under 185, including preparation of the list of all things seized in the course of such search and seizure, and signing of such list by witnesses, shall be recorded through an audio-video electronic means, preferably mobile phone, and the police officer shall without delay forward such recording to the district magistrate, subdivisional magistrate, or judicial magistrate. Please show that recording. Everything that is in the statement will be proved to be a lie. That respondent number 2 took all the devices. It's an absolute lie. And it's contradicted by their own Panchnama in this petition. I read the Panchman out to you. This is very unfortunate, and that's why, in a matter of this nature, and I'll come to the law a little later, this is just to create prejudice. Now kindly come to the Panchnama. 66, I'm going to show you. Page 66. Let's kindly come to 66. We above named Panchas, your lordship sees that? And kindly come, they show that, search was conducted. Now kindly come to 68. Yes, kindly see. During the course of the search, so-and-so inquired about the ongoing proceedings. At 12:05, the search started in the morning. No seizure took place. Till 12:05, no seizure took place. And inquired about the ongoing proceedings, informed her about the proceedings at around 12:15, took possession of material being seized via laptop belonging to Pratik Jain. Now, laptop belonging to Pratik Jain will have all the information about the election. Every piece of information. Several documents and iPhone Pro belonging to Shri Pratik Jain left the premises. Several documents. Where are all the devices? He just read in the petition that she took away all the devices. Contradicted by their own Panchnama. An iPhone. She took the laptop which would have the party information and she took their personal iPhone. That's all, nothing more. And then see for third paragraph. The search was proceedings commenced at 6:20 on 8/1/26 and concluded at 2:50 on the same day. The search was conducted in a peaceful and orderly manner. And no damage to any person or property was caused during the search. The entire proceedings were conducted in the presence of the lady staff and anyway, whatever. There was no obstruction. And signed by ED. So where is the averment in the petition is contradicted by their own Panchnama. Now, what's interesting is there's another Panchnama at 73. Because then they go, to the other office, which is at Salt Lake.
Another party office.
It has party material, election material, which you are aware of, which is why you went there. It is a completely mala fide act on the part of the ED to disturb the process of election and to gather as much material as they can from the office, which has all the material, which is through a contract, which contains all the confidential material. Now kindly come to see the second Panchnama. 74 bottom. During the search proceedings, Ishant Taneja, Pavan Verma so-and-so and other employees joined the search proceedings. They were also explained the purpose of the visit by the authorized officer. Meanwhile, Shri so-and-so joined the search proceedings. He also offered personal search. Officers started the search proceedings in our presence in a peaceful manner. Nothing was seized. Nothing was seized there. Nothing was seized here. From the premises, and no data backup was taken by the team of Director of Enforcement. And the search proceedings concluded at 6:45 p.m. on 8/1. Documents available in the different sections of the premises were not mingled with each other, and the same was left in a proper and orderly manner. These facts were duly acknowledged. That's it.
Contrary to what you are submitting.
I'm sorry?
They had the intention to collect materials from your party office. They would have seized from
They were
you.
just photographing.
They didn't seize anything.
They don't have to seize it. They can photograph.
anything.
They can photograph it. They don't have to seize it. But their lordship
Their
was.
Panchnama says they have not recovered anything. If they had
Well, why did they?
any intention
What?
of seizing your material belonging to your party, they would have seized.
We are not discussing.
They have not seized.
These are facts which will have to discover, which will have to be dealt with, in a writ petition.
We have to examine. You file counter, we'll examine
No,
this.
just.
No, you cannot restrain us from issuing notice.
I'm sorry, of course I can't, I can persuade your lordship, that's all. That's what I'm trying to do,
Yes, please.
I'm only trying to show you
Yes,
the
please.
Panchnamas certainly demonstrate that there was no untoward things that happened, both at the residence of Jain as well as in the office of IPAC. Kindly have a look. So the Panchas, Maharaj, and the Panchnama doesn't say anything of that sort, Maharaj?
Yes, yes.
Right. Now, the other question, one question is, Maharaj, and I told your lordships on 24th February 2024, Maharaj, the last statement in this whole scam was recorded.
Yes, yes.
Then why was the need to go in
That's wrong,
2026?
factually wrong.
I have got, you've got it. I've got it here. Why do you say it's factually wrong?
From
That's
the record
here.
of the investigation.
No, we have it.
Last instance.
We have it here. 23rd
Because
of February.
we are conducting the
23rd of February,
No better.
you have given these details to us. Your petition. Your petition, you say that 23rd February, Mukesh Thakur claims he transferred the money to Goa at the request of Jitendra Mehta, a financier of ACS. That's it. After that, no statement. It's your petition.
That is at page.
Para 12 itself, page 104.
We don't.
Just read it.
All evidence at this stage, my lord.
Ari,
The
you
last
have
statement
your,
is
I'm
recorded
taking your
in
petition.
December 24.
Again, you are interfering. I'm taking your petition.
Sir, come, page eight.
Well, kindly come to page 8.
Page is.
F.
Page F.
Yes.
Is.
S.
Yes.
Okay, I'm sorry.
Which one?
Whatever you give me.
Director of Information.
Yes, you give me.
1 July 2020.
CBI furnished 1720. CBI furnished the second supplementary charge sheet in the proceedings emanated from FIR on 1/7/2024.
Last date, 8/1/26. Concrete material found during investigation.
That's right. So that's precisely the case. That from 2020.
January 26.
That means 2024, why would, what you were doing nothing? Suddenly in 2026, you find material?
On the lighter event, what Mr. Tushar Mehta is suggesting, if money is laundered only during the election, what is their fault?
There is no election, my lord.
That's why this relates to Goa.
That ongoing election. Which election?
Solicitor, you are such a good person. Have the patience to hear us.
My learned friend disarms me.
Well, you're right. There is no election in Goa.
This is not Goa, this is Bengal.
No, this is where Goa, money transfer to Goa.
My learned friend said during election, why did you
During
go for
election
search?
in West Bengal.
There is no election in West Bengal.
Oh, I see. Well, if this is the level of knowledge, Maharaj, that emanates from the solicitor, there's nothing I can say, Maharaj. That there is no election in West Bengal. I'm sure it does.
He's yet to be notified what he's saying.
Yes.
He can say that, Maharaj.
Ah,
He's a very precise lawyer. He's very careful with his words.
I am, my lord. Therefore, I am saying there is no election. Your
There is-
premise is wrong.
Absolutely, there will be none.
And my lord, only one line, my lord.
There will
Allow
be
me
none.
to interrupt.
Allow Maris-
My lord, if the ED officials go to
Can I
their
argue
party
with
office,
Can-
it's not a party office,
Can I argue with
it's an
Mr.
office
Respondent?
of a strategist kind of a, according to them.
No,
What would a normal person do? Please give me a minute.
Can you? No. Allow.
These documents
One second.
have two sets.
One second.
One, my party thinks, and another maybe else.
One second. wait.
Another you can go, but allow me to take my party
Yes.
details.
This-
You have nothing to do with this party
The
details.
solicitor seems to have.
Just takes everything which is shown in the media with files and everything, that I have taken everything. Otherwise, but if there is a scrutiny, say, no, this is my party
Everything
document.
that he says has to be accepted, no, then why are we here? Merely because he keeps on interfering, says what he wants to say, as if, Maharaj, this is the gospel truth. It's not fair. It's not fair on us. Now, Maharaj, kindly see page 38.
1 minute, I'm there in the second petition.
But
No,
you
one
have to
second.
finish it. Let
Finish
the court
that. Allow us to
argue at
finish.
least
Stage
2
of
minutes.
recording of
Allow us to
evidence.
finish.
This was not to be seen.
Now, Maharaj,
by ever-
Co-respondent argue
ever
2 minutes
been
at
We
least.
are arguing only first petition.
Very well.
I'm arguing only the first page. Now, kindly see page 38.
Petition You will be allowed to argue.
The second is,
Don't worry.
yes,
Kindly see page 38, Maharaj. Kindly see page 38.
38.
Yes.
You see, there is some circular issued by the Honorable Chief Justice about time schedule.
Yes. You must
Should
fix it.
apply to
Yes, and interruptions, Maharaj, both.
motion hearing also.
Both.
To regular hearing.
The moment.
yes, but the Honorable Chief Justice also should
Apply to.
issue a circular that lawyers who are appearing would not discuss that matter in public forums like press conferences. That is also.
That also, Malaj, that the CBI should not be leaking information and
Yes.
the ED should not be leaking information
Yes. No, there is no. You
surreptitiously
find.
to journalists of their liking.
I'm.
Therefore, there should be a ban on that also.
Yes, I'm ready to show, my lord, what I've stated.
You can show it. You can show it.
This is not the
Narrative
subject matter of
building.
That's why
Could
Malaj,
also be-
my learned friend always, he's very upset at the fact that I do some program, Malaj. He seems to mention, it's his every matter he mentions this, Malaj.
No,
You should watch
no,
it a little
I'm
more,
very
he'll
happy
understand a
with
bit.
Programs. Don't discuss matters. Don't discuss matters which were.
I'm entitled to.
I have not seen
I'm
any.
entitled to.
No, no.
No, I'm not entitled to. Well, he knows about it.
Mr. Mehta is increasing the circulation of this program now significantly
No, it is.
without watching it himself.
Malaj, page 38. Let's move on to the matter.
Yes, 38, 38.
Yes. Now, what are the offences, Malaj, that are alleged?
Yes.
Yeah, it's all 37, but the offences are, all these offences, abetment, criminal conspiracy, voluntary causing hurt to public servant. No such thing. It's on the face of it. In their own petition. Wrongful restraint, no statement of that sort. Wrongful confinement, force, criminal force. What is all this going on? 130, assault on criminal force, obstructing public in discharge, omission to assist public servant when bound to give assistance, disobedience to order duly promulgated, theft in dwelling house, theft after preparation made for causing death, hurt or restraint, robbery, dacoity, criminal trespass and house trespass and housebreaking, house trespass in order to commit offense, causing disappearance of evidence, destruction of documents. What is all this? This is all contrary to what is in the Panchnama. How can all this happen? And Malaj, all this has to be done how? Under 66(2). Under 66(2), if there is any offense, it has to be reported to the investigating agency of the state. Your Lordship knows 66(2). I'll read it to you. How can all this happen in a writ petition in the 32? Can you see 66(2)?
56.
66.
We have gone through that.
Sorry, PMLA.
PMLA. I saw
Yes,
it,
yes.
866.
Yes, no. 66(2) of PMLA. I read the offences to you just to indicate that all this cannot happen in a writ petition.
No, it has not happened in a writ petition. It has happened there.
No, he is saying these offences have been committed and therefore they have to inform under PMLA if the director or other authority, just read, Malaj. If a director or other authority specified in subsection 1 is of the opinion on the basis of information or material in his possession that the provisions of any other law for the time being enforced, that is IPC, these are IPC offences, are contravened, then the director or such authority shall share the information with the concerned agency for necessary action, which is the state agency.
CBI investigation is.
So, Malaj, so what they are saying is these offences are committed. They say now you must charge them with these offences. We have filed a writ petition, whereas under the statute they have to inform the agency of the state that such offences have been committed. Please investigate. They can't ask your Lordship in an Article 32 to do that. And they are choosing the agency which is being accused by us for mala fide searches. And then apart from all that, and I let my learned friend take it forward, Manas, apart from all that, Manas, the question is, why should the High Court not hear the matter? High Court is not disabled to hear the matter.
I'll take
So we'll take our submissions.
I'll take
But only one
Mr. Mehta, please allow correspondent three
I'm
minutes.
not on the merits. But one response to Mr. Sibbal, a very respected. I personally, you know, I respect him. My objection to matters of arguments being debated elsewhere is not only against Mr. Sibbal.
It's also
Everyone
it's also against
who appear
yes.
in the matter should not give press conferences
my learned
and
friend,
give media interviews justifying or creating a narrative. That's in principle, not in this.
In principle, my learned friend should have no objection. Once a judgment is delivered, it's public property. And this court has said that once it is public property, it can be discussed. And he knows the law, but he doesn't want to reveal that he knows the law.
No, my lord, the incident in question, there is no judgment in law and narrative building.
My learned friend is wrong. There is a.
I leave it at that.
There is a.
No, can I have
I leave it at that.
3 minutes. I heard my lords, Malas, what my lords
No,
said.
we have the entire, about second half bench is cancelled.
I mean, that matter, Malas, it was mentioned without telling us. That bench, Justice Amanullah and your lordship.
Sir, I do not know your boss, but your advocate on record was
But
informed
then
that
let
he was
me, my
present.
lord is saying something, let me
No,
respond
council
to
has
my lord.
He was
requested,
present.
it was cancelled by the bench, by the
I see.
court, not by the any
I was
request of
told
any.
somebody mentioned it, he told us
No,
after.
no, my lord, we
Anyway.
mentioned with presence of his advocate on record,
Anyway,
with consent.
What Mr. Singhvi
I
said.
can apologize.
in fact, the court said that we'll
what
fix
Mr.
a date
Singhvi
later.
said He should have been heard before cancelling the bench.
No, I should know it.
Understand
Yeah,
why?
yes.
They have long
My lord,
conflict.
he can,
They do and they should
Understand
hold
why
my
can be
increase.
deemed as having been heard, my lord, for all purposes.
Anyway, with this,
So in that bench,
all these
that
digressions.
bench he
let me
said,
come.
2 p.m. bench, that he should have been
I know
heard
Justice
before
Amanullah's
cancelling the
bench.
bench,
Anyway,
so that it should have been
Let me
recorded
come
in the
down.
order sheet that he has heard. Yes, next. Please.
because people come and have long conferences, discuss matters, and suddenly they mention without telling us. That's why I was
Yes,
complaining.
yes, you are right.
Anyway, brothers.
You are right.
Now I'm going to make 3 or 4 points in less than 2 or 3 minutes, brothers. One is we have serious objections to the maintainability of this so-called Article 32. In the highly unlikely event that your lordship issues notice, your lordship should make it clear as a caveat that it is subject to a very strong preliminary objection on maintainability, which shall be alive.
Yes.
There are judgments which say that an ED or a statutory body like the ED coming straight into a walk-in system of 32 requires very grave consideration. It is allowed in exceptional circumstances where, Malas, it is necessary that the ED is virtually remediless. That's the test. That's point number 1. I propose to raise it, Malas, strongly, both today and in any eventual hearing.
You are appealing for state of
I am
West
for
Bengal.
1 and 3, state
State
and
of
police,
West Bengal.
state and DGP. 1 and 3, he's for 2. Point number 2, Malas. I also intend to raise the preliminary objection of forum shopping with your lordship's well-known case law, because what your lordship is concerned about is that this petition is filed after my learned friend files an identical petition. Lordship will take my word for it. The prayers are virtually identical
We are in High Court and
in
here.
High Court and here. Lordship need not waste time seeing it. Lordship will take my broadly, substantially, it's identical.
Yes.
Now you are the petitioner there, you are the petitioner here. Yes, you had a fracas on a certain day, on 9th. That cannot be an excuse to maintain a parallel riding 2 horses.
Why should it happen at all?
No, Malas, that's a different issue. We'll answer that. I understand my lord's concern. And don't think I don't appreciate my lord's concern. I don't think any of us hold a brief that should.
Today it is this High Court, tomorrow the
No, Malas.
other High Court.
Sometimes, Malas, emotions go out of hand and they can't be controlled. That, Malas, please don't misunderstand me that I'm not understanding my lord's concern. And that, Malas, I don't think anybody will hold a brief. Perhaps, Malas, emotions go out of hand and we are not able to control. But the relevant test is yesterday.
No, you see,
Yes.
emotions should not go out of hand regularly.
No,
In an
it's not.
orchestrated manner.
And then on 9-1, again, emotions
What is
go.
Now, Malas, may I just say, we are now, Malas, talking of R1 and R3. I am saying this, Malas, that the relevant date for considering forum shopping is yesterday. I understand, I am not belittling what is falling from my lords. Keep that 9th apart for just 2 minutes. Yesterday, everybody was in court. It is not even your case that anything untoward happened or was attempted or even started. Why on earth, you having filed your own petition in High Court, the next day having filed in Supreme Court or 2-3 days later filed in Supreme Court, then make a statement to the High Court yesterday, please don't hear me, and the High Court is supposed to pass such an order, Malas? Anyhow. It is not that you are getting this date yesterday because of the ruckus. Kindly give a copy, no? Why don't you give a copy? So, Malas, in effect, the High Court is told, I am riding 2 parallel horses. I am telling your lordship I am riding 2 parallel horses. But you please stay your hand. And the High Court records this order, 1-page order. I am adjourning it sine die. Obviously, Malas, in Committee of Courts and Superior Court and all that, Malas, it's the right thing to do. As far as the High Court is concerned, I am not blaming them. I am, Malas, on the conduct. So this is forum shopping. I again take the strong preliminary objection. My third submission is, Malas, the Panchanama, which has been read. Malas, that has been read. I am not repeating it. But just note the relevant words, only the operative words, 3 lines, which your lordship has seen, Panchanama, which has been read already. It's been read, but just the relevant lines, Malas, at 66 to 69.
66.
Yes, 66 to 69. These words are important. That's my third respectful submission.
That page?
Well, it's at page 60. This particular portion is which page?
8.
68. 68. You also use the first one.
Yes.
Please, you don't go to thinking. If you Lordship, at just the penultimate para at 68.
Yes.
This is relevant. Ultimately, what is relevant is this, to tell you that he snatched the papers, he ran away, he did this, he assaulted somebody. What is relevant is this, either you are lying or your petition is lying. Third, penultimate para, second line.
Yes.
The search was conducted in a peaceful, orderly manner. Each word is important. No damage to any person or property was caused during the search. Entire proceedings were conducted in the presence of lady staff and no religious sentiments were heard.
Leonard Finn may read the 2 paragraphs above.
What peaceful
Two
means?
paragraphs
Peaceful
above.
from their side. That's
I beg
what
pardon?
they mean to say.
2 paragraphs above what my
From
Leonard
the
Finn.
English side, not from your side. That is what probably.
I'll read whatever you want me to read, I'll read it, Bullet.
Not the relevant section. Let him,
Yes,
They
yes.
have done it peacefully.
No,
let him read the 2
the
paragraphs.
previous
above.
para which he's asking
2 paragraphs
to
above.
face,
My Leonard
respond
Finn may not
Mr.
do it
Raju,
peacefully.
please.
Let him read.
It is not denied by our.
Take Mr. Raju that what he is reading.
We didn't interrupt once even, Malad.
Yes,
It took a long time.
Please, Mr. Singh.
Mr. R2, Mr. Sibbal, has admitted that the CM was, the president of the party was there. So what is so great about this para? This para says that so and so time, so and so Miss MB took possession of the material, etc., etc. That's all. Nobody is denying that she was there. Now, these are derailment. I have a different point. I am saying that with this Panchanama, what
ओह नो, बाइक का एक्सीडेंट हो गया और अब समझ में नहीं आ रहा कि क्या करें। टेंशन किस बात की, डिजिट है ना, वीडियो बनाओ और डिजिट ऐप पर क्लेम डालो। डिजिट बाइक इंश्योरेंस लेना और बिना टेंशन जीना। रिन्यू योर बाइक इंश्योरेंस टुडे।
have you heard my sentence, you realize. I mean, you don't be presumptuous, Mr. Mehta. You started your search at 6:45. The email is 11:30. In which calendar, from which Gregorian or non-Gregorian calendar does 11:30 happen before 6:45? I'd like to understand that. So before you interrupt, get your instructions right. You're only, that's why I said, obviously, if I'm searching his house and I send an email 11:30 to create a paper trail, I started searching the house at 6:45, 5 hours earlier. And my learned friend says it was beforehand informed. In the middle of Balas, the persons are there. Some police officer will go start reading emails. 5 hours earlier, event has happened. So this is a very clever way to cover up your tracks. A person who sends an email 11:30 for a search which starts at 6:30 is covering up his tracks, creating a paper trail to tell your lordship later on. My next point is, Balas, that the question he raised, I'm only answering that, but I'll have to put it down if necessary. I came there because a Z protectee, a Z class protectee, was informed in an FIR number 5 of 26 that unidentified persons who refused to identify themselves had entered this place and were dealing, and the Z class protectee had reached there. So naturally the police rushed there. That's all that happened. Now, Malats, the ED officials identified themselves much later. They did not identify themselves because the only identification would be a prior written intimation at 6:45 that I am Mr. A, Mr. B, Mr. C, we are going there at this time, or at least just before that. So, Malats, that is why I went there. That is nothing sinister about that. And whether she is a chief minister or a president of a party, she remains a Z plus protectee. So, Malats, the moment we come to know, we have to move. Well, in the light of this, the Lordship may consider, I leave it to my lords, that we put in, if your Lordship is so inclined, without notice also we can put in a reply saying these points. Otherwise, leave it to my lords.
Otherwise, you will say 6:25 p.m., 11:30 p.m.
No, I will put in these things where Lordship wants me to put in.
Legal things should
So
be
there
done
are
in a
other
legal way.
respondents also.
Should be done in a legal way.
Anyway, I don't know. That's all I have to say.
Yes. Yes. You're for?
I'm appearing for respondents 4 and 5.
In first petition.
Yes,
Because we are yet to hear the second petition.
it's in both the, it's in both the,
No, Mr. Raju wants to argue the second petition.
first petition,
First petition, respondent 4 and 5.
5 years. So I just have a very small point. Your lordships may just consider that the appropriate order perhaps in a case or a situation like this, your lordships have seen that the hearing which took place on the 14th was in a very orderly manner. So I would respectfully submit that that is the subject matter of a 226 petition. Let that matter proceed. The lordship wants to reinforce because the Chief Justice's directions are very clear. It's proceeding in an orderly manner. It ought not to be, that's my suggestion, that the 9th January disruption which took place when the court itself could not hear the matter, that shouldn't have a lingering effect which persuades this court to issue notice under 30. So let us see what happens, my lords, on the adjourned date or the next date as far as the 226 is concerned. If that proceeds smoothly, as it will, I mean, we expect that it will, that's a much better way of going about it, my lords, rather than this. I would respectfully submit that statement, at least at this point.
Yes, Mr. Raju.
There are several submissions that I have to make. The first submission is the recording of an FIR only requires that prima facie a cognizable offence is made out. If the averments in the petition make out a prima facie case that a cognizable offence has been made out, that's the end of the matter. Lalita Kumari is very clear. No inquiry is required, no accused is required to be heard. The defense is not to be
You
considered
are
at that.
speaking about which FIR?
I'm asking for the FIR, which I'm asking to be registered and CBI investigation.
Oh, yes.
For that, I'm making my submissions. So if my petition discloses a cognizable offence, then a FIR has to be registered. Nobody hears an accused before an FIR is registered is unheard of. We have made them respondents by way of abundant caution. That is what we have said without conceding the right. That is my petition says. I've said that in paragraph of my petition. I'll read that paragraph. This is one paragraph. Now, therefore, the issue that arises is, has a cognizable offence taken place? On admitted averments, the offence of cognizable offence has taken place because an offence of theft. I have pitched my case a little higher. It is not only theft, it is robbery and it is dacoity, because more than 5 persons were there. Some policemen were armed and there was wrongful restraint. But forget that. Simple case of theft, which is a cognizable offence, is made out on admitted averments in my petition. If that is so, the issue is who should investigate. If a cognizable offence, FIR has to be registered. That's the settled law in Lalita Kumari. May I read Lalita Kumari or
Yes, read.
give me Lalita Kumari? Come to back. Kindly.
You can continue.
I'll not take much time, but I'll only make, kindly have a look at para.
You argue, we have no difficulty.
Kindly have a look at para 120 onwards, conclusions.
Yes.
By
Para 5.
120
Para 120.
at page 61. 120.1. The registration of FIR is mandatory. Kindly note my mandatory under section 154 of the code, if information discloses commission of a cognizable offence and no preliminary inquiry is permitted in such a situation. So if the petition discloses a cognizable offence, it is mandatory that an FIR has to be registered.
Paragraph 120.1.
Yes. I have demonstrated that a cognizable offence has taken place. One doesn't say that you have to inquire from the accused why you have committed the offence of theft. That is not the scope of registration of FIR. You have to look at the averments made by the informant, in this case in the petition, and if it prima facie makes out a case of theft or a cognizable offence, FIR has to be registered. Therefore, whatever they are saying, we went there because of a party document, which is wrong. Otherwise, no FIR would be registered. The entire purpose of the scheme of the CRPC would be frustrated. This is number one, Manoj. The second is, ordinarily, I have to go to the local area where the offence has been committed to get the FIR registered. But this case stands on a different footing. Your Lordships have permitted deviations from the normal rule. Why the local police should not be permitted to investigate? Here, the Chief Minister is an accused. She is the person who has personally committed the theft. This theft was committed in the presence of the Director General of Police, who could be an abettor. It has been committed in the presence of the Police Commissioner of Calcutta, where the offence has taken place. So, head of the police in West Bengal is accomplice as far as the offence is concerned. Police Commissioner is an accomplice, and she is the Home Minister. So, no FIR, if it is registered, even if it is required to be registered, will be inquired and investigated properly. Now, the law is, kindly have a look at three judgments. In this case, if the highest authorities are involved, then the CBI investigation is to be ordered. But kindly have a look at, one is KV Rajendran versus Superintendent of Police, 2013, 12 SCC 480. 480.
480. Para?
Era would be 17. Where they say if the
70.
17. It is extracted at page 31 of my petition, Manoj.
Page 31 of your petition.
Yes, of the first petition also, my lords, we can have a look at it.
Then
In view of the above,
page 480.
page 31 of my petition, my lords have got it?
481.
480 para 17, Manoj.
13, 12.
I can hand over a copy also.
No, we have
In view of
para 17.
7.
In view of the above.
In view of the above, the law can be summarized to the effect that the court should exercise its constitutional powers for transferring an investigation from the state investigating agency to any other independent investigating agency like the CBI only in rare and exceptional cases, such as where high officials of the state authorities are involved, or the accusation itself is against the top officials of the investigating agency, thereby allowing them to influence the investigation, and further, that is so necessary to do justice and instill confidence in the investigation, or where investigation is prima facie found to be taken. This is at the stage of investigation, but prior thereto also it can always be exercised. Then kindly have a look at the second judgment, my lord, 2014, 8 SCC, page 682, para 86.
Oh, then 14.
2014, 8 in SCC, page 682.
Last but one page, just for easy reference. Last was third.
It is the para 86, Supreme Court page number is 736. The criminal, it starts like the criminal justice system mandates that any investigation into the crime should be fair in accordance with law. So if it is investigated by the accused or somebody subordinate to the accused, it can never be fair.
Yes.
In accordance with law, it should not be tainted, it would be tainted. it is equally important that interested and influential persons are not able to misdirect or hijack the investigation, which would be the case if the local police are asked to investigate, so as to throttle a fair investigation, resulting in the offenders escaping the punitive course of law. These are important facets of rule of law. Breach of the rule of law, in our opinion, amounts to negation of the equality right under Article 15. Therefore, my lord, I can come here directly because otherwise my right under Article 32, fundamental right under 14 would be infringed. Therefore, I can come directly to this honorable court, even under 32. No need for me to go before the High Court. Then, my lord,
why can't you continue in the High Court?
I'll tell my lord why.
You answer it after we come back post lunch.
Very well, I'll answer.